night. 94.4 Spice FM, Nairobi.
How are you waking up this morning? It's 6 minutes after 7 o'clock. This is the Situation Room. Karibu Sana. And as you join us, our audience on KTN, you're joined by folks on our live stream on Facebook, on YouTube, and on X, on radio around Kenya, indeed, in the region and the world. It's Kenya's biggest conversation. As you do that, we're getting into day 2 of getting into school, and you're wondering, okay, this back to school season, how are we going to do it and get everything into the basket that's going to be needed to send children back to school? Well, how about you go to your home of deals? It's Naivas. Naivas has walked and celebrated with Kenyans through many a season. And how about term 2 to do that yet again? It's the longest term of the year, and Naivas is right here with you once again as you prepare your children for the new school term. And maybe there was something that you didn't get as you were going back to school yesterday. Don't cut corners while doing your shopping. Get everything that you need fully loaded at your Naivas Kiloko near you, and make every item count with Kijaze, Kikapu, Kibonge. Enjoy unbeatable discounts, low prices every day, and a full range of back to school essentials. You can do this in one place all day. Make the season a breeze and turn you into the hero they see you as, walking with them every step of the way in their educational journey with Naivas, Kijaze, Kikapu, Kibonge. So, as you walk into an Naivas this morning, those are the things that you will then be able to get. We're getting into the first conversation for the Situation Room this morning with someone else, and that is James Mangerere, who is the president of the Mediation Training Institute of East Africa. We're having a conversation this morning about promoting private mediation practice in Kenya, and we're going to find out what that's all about as we get into that. Mr. Mangerere, good morning.
Morning to you.
How are you?
Fine, thank you.
Karibu Sana.
Sante.
Thank you for being in the hot seat of the Situation Room.
Good.
Before things get hotter, CT, as you may know, goes around the African continent. He brings proverbs back from each country that he goes to every week. He'll tell you which country he's landed on the shores of today, and then he'll share the proverb, and then we will ask you to interpret that proverb for us. Yes?
I'm ready.
Okay, super.
Good.
We are in the People's Democratic Republic of Algeria. The proverb, this is me reading my own things here. A friend is someone who shares your happiness and your sorrows.
Yeah. I think a genuine friend is a person who is available in all circumstances. So I think if you have a friend who only shares your happiness, and then when there are sorrows, is not available, that's not a friend at all. Yeah, because a friend in need is a friend indeed.
Absolutely.
Yeah.
I mean, a great one. Where do we have nothing to add, isn't it, or to remove from that? I mean, so getting into the conversation this morning, James, as president of the Mediation Training Institute for Africa, we've heard of mediation as an alternate justice resolution mechanism, and that you don't have to go to the courts, but that you can actually sit one-on-one. But then we want to learn a little bit more about those processes today and seeing about promoting it in the private. That's between two parties. But then let's look into that in terms of what it entails and what the Mediation Training Institute of East Africa actually does. Maybe we start from there and then see then how mediation as a private practice can actually work.
Well, I think it's important for people to know that mediation is an alternative dispute resolution process. And we have so many other alternative dispute resolution processes. We have negotiation, mediation, conciliation, arbitration, adjudication, and many others. But you find that the superiority of the mediation process is that you empower parties to make their own decisions, unlike the courts or arbitration, where you have to present your case before a third party, and then that party makes a decision on your behalf. And people, when they make their own decisions, they tend to respect them. That's why decisions made by parties themselves are also decisions that people are ready to respect. Yeah.
When you say people make decisions on their own, please walk us through this. What do you mean? You are in a process of mediation because people have some differences.
Yes.
And it requires a resolution.
Yes.
So how then do they arrive at a decision made by themselves?
You see, people start resolving their disputes through direct negotiation. When direct negotiation fails, when the communication lines are closed, A third party is then invited to come in and assist them to negotiate, to open those lines of communication. However, this third party is neutral. The purpose of this third party is to facilitate negotiation, which the parties have begun already, but they couldn't make any progress, and therefore they needed assistance. So this third party now comes in, who is trained, properly trained, to assist open these lines of communication. Yeah, that's the purpose of mediation.
So what kind of cases would you say come to you often?
Yes. Well, there's mediation resolves everything. In fact, initially, people used to say mediation cannot resolve criminal matters. It's now, they have been proven wrong, because already criminal matters are being mediated. So we have commercial disputes, we have family disputes, we have community disputes. Now, we have even gone further. Even medical negligence disputes are being resolved through mediation. We have telecommunication disputes resolved through mediation. We have environmental disputes resolved through mediation. Insurance disputes that usually had to go to court these days can be resolved through mediation. That's motor vehicle accident disputes, personal injury claims, because you can, even in courts themselves, they quantify and they can tell you how much you can be paid if your hand is broken.
Right.
Therefore, anything that has got figures involved in it can be mediated.
So how do we know, or how do we decide that something can then go towards mediation? CT stole my 20 cows.
Yes.
Okay.
Yes.
We have him on video.
Yes.
And I've said, look, I want my 20 cows back,
Yes.
or at least I want compensation for them. And we go into this whole hullabaloo,
Yes.
and we're trying to. How then do we say we shall not go to court, or we shall not go to the police, but we shall say, let's get into a room and get a third party who's been trained to now mediate between two of us? I do want my cows
No,
back.
wait. I passed by the gate, the cows followed me. What was I supposed to do?
You should not have taken them.
Good.
You should have returned
I
them to
think
the
what you
gates.
want to bring about is the criminal aspect of mediation. Now, let me tell you, in our criminal justice system, we have what we call, we usually, when a crime has been committed, usually you say it's a crime against the state. It's not against the individual. That's why you see when somebody is taken to court, it's the republic versus that particular person. You are ignoring the victim. That's why we have now a system we call victim offender mediation, which is restorative justice. You see, for example, let's talk about the case of somebody was committed murder, because I've seen a case of murder being mediated.
Really?
Yeah, and find a case of Muhammad Abdul versus Republic, a case that took place in Isiolo.
But murder is a capital offense.
Exactly.
Can we? And I thought
Our constitution allows 3 ways of resolving disputes. Article 159(2)b clearly indicates 3 systems of resolving disputes. That is litigation, alternative dispute resolution, and traditional dispute resolution mechanisms. In this case of Muhammad Abdul versus Republic, Muhammad Abdul committed murder. He was arrested and taken into police custody. Now, while the police were preparing to arraign this person in court, the father of the deceased and together with their family, the 2 communities sat together, and they agreed that they'd be paid 50 camels as blood money. And therefore, the father of the deceased did an affidavit to the Director of Public Prosecution and asked the Director of Public Prosecution to withdraw the matter.
Okay.
Based on Article 159(2)b of the Constitution. The matter was withdrawn.
Okay.
And settled.
So my question is,
Yes.
how do you get to that point when we have an issue?
Yes.
How do we get to the point whereby we say, fine, we are not calling the police, or even if we have called them,
Yes.
or we are not going to court, or even if we have placed something in court, how do we get to the point whereby we say, can we mediate as opposed to following this other process?
It's important to understand this concept, the philosophy of restorative justice. The philosophy is that even if a crime is committed against a state, it doesn't mean that the offender who has already been convicted and taken to court is released upon mediation. But one thing is very clear. Most of these offenders, when they come back to the community, they can't be accepted because they have stigma. Assume there's somebody, for example, who committed rape, let's say rape, and they were been sentenced to prison. What we do in victim offender mediation is to prepare the victim, prepare the offender, and bring some representatives from the members of the community. Now, the offender is given an opportunity of expressing remorse to the victim, and the victim starts the process of healing. Now, the members of the community who are present, the victim goes back to court, to jail, and serves their sentence. By the time they come out of jail, they are welcome in the community because members of the community were involved. This is a process that works everywhere in the world. And in fact, it's very slow to be applied in Kenya. But the concept or the philosophy of restorative justice has been working in other jurisdictions. It can work also here because we only believe in retribution in Kenya, punishing the offender. And we ignore the victim completely. What happens to a person who has gone through a heinous crime like rape, for example? They are left to suffer, and the process of healing doesn't begin because the offender has not been subjected to an environment where they can accept and show some form of remorse and be given something like a community service and go back and serve their sentence. By the time they are through with their sentence, when they come back to the community, because they have shown remorse, the victim has healed. Number two, because they showed remorse, members of the community are able to accept them back to society, and this reduces this element of criminality.
Are we saying that courts don't? Sorry, guys. Are we saying that courts do not create an environment whereby remorse can be shown and or felt?
That's not available in court. In fact, what is available in court, courts will only focus on the law and the facts, and they will send somebody to prison to serve the sentence according to the law. Issues about remorse, those things are not, the courts are not trained to bring on board issues to do with emotions. Emotions can only be dealt with in an environment of mediation.
Okay.
Yeah.
Yeah. Yes. So here's a question where you say when someone commits an offender, it is an offender that is against the state,
yes,
right? But here is a question where through the justice system, one tends to trust the courts more than the mediation process because one would feel as though
yes,
they are shortchanged.
Yes.
So then how do we change this perception that mediation, someone can cut through, that it will not give the justice that is required? How do you deal with that perception?
First of all, was one thing I want to know. There are cases that are not mediatable. That's why the reason why it's important to be able to identify a case that is mediatable. There are some cases, especially development, where the victim is not in a position even to consent. We cannot touch those. So there's a classification of cases that cannot be mediated. Now, the problem we have is education. Most Kenyans do not know what mediation is. We have not invested enough time to educate the public and create a culture we call a pro-amicable dispute resolution culture. That is the beginning. When I was talking about private mediation, we must begin with the culture of Kenyans, because Kenyans usually, when they are offended, the first thing they will tell you is see you in court. And when you get in court, you don't even speak. You give it the opportunity to the lawyers to speak on your behalf.
You may not
who
even
may
be
not
there.
even understand the substratum of the dispute. Lawyers, I'm a lawyer too. We are not trained on how to deal with emotions. And human beings are 90% emotional, 10% rational. Courts are looking for rationality. So creating that pro-amicable dispute resolution culture is what we begin with, even as we talk about private mediation. And also we need a very strong legal framework to support mediation. Right now, the legal framework we have only supports court annexed mediation. Private mediation also requires a legal framework. We are working around a mediation bill to be taken to Parliament, which will then institutionalize mediation and manage standards of practice of mediation. That is the moment the Kenyans then will understand what mediation is, and because it's been legislated, there is a law that will regulate the quality, the standards of practice, the quality of training, and many other things. Right now, all the problems we have is because we do not have a specific legislation that regulates all this stuff. And most Kenyans, in fact, do not know what mediation is. And even the Bible says, "City, my people perish because of lack of knowledge." Every time we rush to court, the cases take 2, 3, 4 years in court, and you know very well that justice is delayed is justice is denied. In mediation, disputes are resolved faster. The reason why this is not in the public domain is because we have not taken time to educate the public about the importance of this process. In fact, I've gone through different parts of the world just to study how mediation has grown. And the reason why I'm coming here today is to see how we can promote private mediation in the country. I've been in Dhaka, Senegal. I went to the villages and saw how mediation centers are working very well. And in fact, the courts have very little to do. I've been in Colombo, Sri Lanka, just to study the way they handle their own private mediation. I've been, 2 weeks ago, I was in Sao Paulo, in Brazil, just to I went for a mediation competition, but I took time to talk to the mediators in that field and how much mediation has developed in that particular part of the world. There's a lot we can emulate from these parts of the world on how we can promote mediation internally. And this is the time to do so, because Kenyans, we have all concentrated on court annexed mediation and forgotten that private mediation also thrives.
So there is, you've mentioned something that is critical. Just make me understand. You
Yes.
said that there is no regulation, because now is when you're working on a
Yes,
bill
yeah.
to make a law
Yes.
that will then come up with regulation,
Yes.
which begs the question, then how are you operating without all this?
It's only the courts that have rules. We have our rules. We have the legal notes number 145 of 2022 that regulates court annexed mediation. Private mediation has been included recently in those court annexed mediation rules, but we need an act of parliament. There is a law that is required, because if we leave this mediation open, everybody is going to be a trainer in the field. Everybody will practice the way they want. Within a very short time, mediation will be rubbished. It will lose the reputation that it has in many other parts of the country, of the world. Look, in Kenya, we are almost 5,000 mediators. Court annexed mediation only handles about 1,500 mediators. What happens to the rest of the mediators who are in the field? That's the importance of promoting private mediation in the country, so that we make it a profession like any other. There was an interview I had in another TV station some years back with the president of the International Academy of Mediators, who was asked on TV, how much do you make in a day in mediation? And he said $9,000. People were surprised. $9,000 when they look at Kenya shillings. These people, especially in the United States of America, were in the state we are only 25 years ago. But the mediators came together and they developed the infrastructure. They came up with the regulations, what we call self-credentializing systems. Right now, mediation is a business. In all the sectors in America, come to insurance, manufacturing, medical, employment. Before people move to court, first of all, they have to go through mediation. In fact, there is what we call a mediation policy in countries like America, Canada, and others. You will not be allowed to file your case in court unless you have gone to mediation. Before you file your case, you have to present a certificate in court that you have attempted mediation, it has failed, and therefore you bring the case before the courts. And that's how most parts of the world have developed.
Let
and
me
we can
ask
get
this
there.
question. The
Yes.
court annexed mediation,
Yes.
you gave a figure and you said they only handle a certain number of cases.
No, I'm saying about the number of mediators who have been accredited by the
You
courts.
said those are 5,000.
They're 1,500, but there are mediators outside here who are up to 5,000.
Yes, there
Yes,
are 5,000 mediators.
Yes.
So you're saying that the courts have only accredited 1,500.
Exactly, approximately.
Why only 1,500?
Well, it is the capacity also, because these mediators in court have to be paid. And the judicial budget is also limited. Number two, those people have to apply and be interviewed and be accredited. That's the capacity that the courts can take, which means we have other mediators out here who are qualified but are not accredited by the courts. So unless we develop private mediation, it means people are going to be accredited. They are going to be certified,
But
and they will not practice mediation.
If the courts accredit you,
Yes.
must you work for the courts?
Not necessarily, but when they accredit you, they assign you matters from the court. You are sure of getting at least a
My
matter.
question exactly, must they assign you?
Well, it's not a must, but depending on the availability of cases, they have a system right now which is computerized, in fact, where they have all the list of their accredited mediators, and that system assigns cases. And if you have already been assigned a case, it will not assign you another case unless you complete what you have.
Let me ask,
Yes.
when somebody is a qualified mediator,
Yes.
who determines that you're qualified?
That's an issue that is very important. For example, if you have been trained by Mediation Training Institute, number one, we are accredited by the International Mediation Institute, which is a worldwide body based in the in Netherlands. We are accredited by the Singapore International Mediation Institute, which is based in Singapore, which means our program has been subjected, scrutinized, and approved as meeting international standards. Locally, for the lawyers that we train here, we have been accredited by the Law Society of Kenya, because the lawyers we train usually are accredited 3 CLE units, and many other international bodies that have recognized the standards of training. Now, there is no body in Kenya that accredits training institutions. Only they can recognize you as having a program. That's why right now we have about 42 organizations.
Who accredits the schools of law? Who accredits it? Who is it who created what we know as the Kenya School of Law?
Yeah.
Whatever you know, it's got a different name now.
There's an act of parliament.
Aha.
Exactly. There's an act of parliament that regulates those institutions,
Aha.
which accredits them, which you don't have in mediation right now.
Why?
Because exactly that's the reason why we are working on this act of parliament, the mediation bill that we are working on to place before parliament. And unless we do that, there will be so many institutions outside here claiming to be crediting you, because the only thing you need to do is just do a register your company and print certificates from the system and give it to people.
You know, I find this strange. And the
Yes.
reason you find me sticking on this question
Yes.
is this. Our courts are manned by people who have studied the law
Yes.
and have gone through the processes,
Yes.
have gone through law school.
Yes.
Everything that allows them to practice as they're practicing is a process that has an umbrella that enables them to do this.
Yes.
They then accredit mediators.
Yes.
Okay?
Yes.
Why is that accreditation not sufficient? Because the very people that they are... Let me broaden it.
Yes.
If you actually want the alternative justice system to work,
Yes.
okay?
Yes.
Are we saying that it must work under the supervision of the courts?
No. Not at all.
And even if it were,
Yeah.
are you saying that the courts must be the people who are responsible for the payment of these people? Yes. Can something not be worked out so that you actually are accredited in the same way as those are, but you practice?
Exactly. That's exactly what I'm telling you. Like now, most organizations in the world, the courts can only accredit these mediators, people who manage the courts, cases that are within the courts.
Okay.
That's what they do. But any other private mediation outside here, we have different institutions that are accredited. Like for myself, I do international cases, investor-state disputes. Those cases which I do are not with the permission of the Kenyan courts. I'm accredited by international organizations which have put me in their systems, and therefore I get cases and I do them. I do for the World Bank and other organizations. Now, what the courts are doing is limited to only court-annexed mediation programs, nothing more. And that's why it has got those limited number of people. Now, outside here, private mediators, people open their own offices and they carry out private mediation. These people need what we call self-credentializing. We have the Institute of Chartered Mediators and Conciliators, ICMC, which is an organization, which is an African organization, which is trying to create standards and organize mediators who can be able to offer private mediations within the continent of Africa. The problem is when people, especially a person from China or another place, comes to Kenya, they have a dispute and they are looking for a credible mediator. They may not go to court. They may look for an institution that has got a group of people who are bound by a very strong code of conduct to assist them get a credible mediator to be able to help them resolve their disputes. And that's the purpose why the Institute of Chartered Mediators and Conciliators was built, and which is what we are working on to promote and ensure that we credentialize our own mediators in the African continent, which will then support people, the credible mediators where people can refer their cases to.
Okay.
So courts are limited. Courts will only accredit mediators who work within the environment of the court, who receive matters from the court.
Okay.
But for private mediations, unless we do have a legislation that can manage this process, then it means people are left free.
Okay.
Anybody can call themselves a mediator.
Is there any kind of education or training
Yes.
that is necessary for a mediator? I ask this because
Yes.
you will have different subject area disputes
Yes.
in different industries,
Yes.
whether it is in airlines, whether it is in law, whether it is, in commercial business. But the mediator who is coming in, must they have some kind of training or at the very least understanding of the industry that they're in? And can you be a subject area mediator?
Exactly. The International Mediation Institute has set up a syllabus. This is an organization based in the Netherlands, has come up with a syllabus which organizations worldwide adopt. They have standards of practice which they adopt. Now, these are the basic principles. That's why we have basic principles in mediation, and then we have advanced principles in mediation that people study. Now, if, for example, I'm doing a medical negligence dispute, and I'm not a subject matter expert in that particular area, and CT is a doctor, but a trained mediator. What we do is I call a bond city to come and co-mediate with me. There's what we call a co-mediation. Technical issues especially will require things we call co-mediation. Therefore, if I'm doing, for example, an environmental dispute and I'm not good, I don't understand the technical terms in environmental mediation, I simply call in a co-mediator, or I ask the parties to allow me to bring on board a subject matter expert to assist me understand the substratum of the dispute. That's what we do. I've resolved issues, technical. I've done some technical mediation in areas I'm not very good at. Because usually what I do is to request the parties themselves to allow me at their own expense to bring in an expert to help me understand. The same way we do even with the courts, to help me understand the dispute so that I can be able to help them resolve their dispute. So it's either through co-mediation or the invitation of an expert to assist you to understand the substratum of the dispute.
So we talk about the syllabus, yeah, and when you come to the legal fraternity in the country, there are two institutions that are very key when it comes to legal education. So we have the Commission of Legal Education, or the Council of Legal Education, and the LSK, who manage everything to do with law. Here we talk about a syllabus that is recognized internationally. But how then do we tie that with the Kenyan syllabus and the institutions that manage the legal profession in the country here for you to get accreditation and whatnot? How do we tie that together?
It's very important to know that the mediation and law are separate bedfellows. They are not the same. But people have always associated mediation with the law. We have so many mediators who are not lawyers.
No, they don't have to be lawyers. But whatever it is that they use as their tool for mediation is the law, is it not?
You are talking about legislating mediation.
No.
Yes.
I am saying when an issue is brought before you and people have a dispute. Are you saying that legal issues do not come into the discussion?
Exactly. That's what I want to be very clear about.
Yes.
We look at, we don't know, when you talk about legal issues, you are talking about the rights of individuals.
Yes.
We are not interested in that in mediation completely. We are looking at the interests of the parties. Let me tell you a big difference which people need to really understand. When we look at the law, if we start looking at the law, there are so many mediators who don't even understand what the law is. And I can give you an example of this. There's a dispute I was doing about a family dispute. So, in family disputes, usually you'll find that parties will come with the Marriage Act 2014, Married Women Properties Act, and the court file. That's not our focus in mediation. Our focus in mediation is in the interests of the parties and the best interest of the children. And therefore, we are looking at the fears, the concerns, and the needs of the parties, which is different from the rights of the individuals involved. We isolate the law completely from mediation, and people should really understand that.
Let's take a break at this point, and we're going to come back and look at that just a little bit more, because this is really the crux of the matter. Because we always want to link cases where something has gone wrong to what the law can do or punish someone. And maybe there's more that we can get out of it. James Mangengere is the president of the Mediation Training Institute of East Africa. This is our conversation for this morning at 26 minutes to 8. We'll be back right after this to continue.
Situation Room, the only way to start your day.
It's the Situation Room. And as we were going to the break, James, you said, you know what, we're trying to shift the focus a little bit, whereby all parties in a case, usually it has been, you did something to me, I call police. Police says, fine, we go to court, we settle that, you settle me, right? But from what I understand, and maybe you can delve into this a little bit deeper, is that with mediation, that they're both sides. No matter how thin you slice it, a story always has two sides. And both of these sides, in this case, no matter who the offender might be, that they both have something to be listened to and something to be heard. Is that the direction that mediation takes?
Exactly. One thing I want to tell you is to be very clear. We need to know the differences. We have talked several times about the alternative justice system. Alternative justice system is not mediation. It's very important to understand that. Mediation is an alternative dispute resolution process, not an alternative. Alternative justice system is a process where sometimes you call in the police, the elders, and they look around something and then they make a decision. Know this difference very clearly. Mediation and alternative justice systems are two different bedfellows completely. They don't use the same philosophy or concept. Now, one other thing I want people to understand is that we are concentrating more on mediation, especially on criminal matters, because it has always been taboo to mediate criminal matters. There's a book I came with. I don't know if anybody can see this book, known as Mediating Criminal Matters, by a gentleman known as Pascal Confilas. He has told people clearly that, look, we have always said, even in Kenya right now, we are saying about mediating criminal matters. They are being mediated every day. Go to our courts. People are going to prisons, identifying matters, and there's what they call conversion. Matters are being taken away from court and taken into the elders for the purpose of resolution. The statistics that we have is that 86% of Kenyans don't go to court when they have a conflict. 86%.
Even though they say I'll call
Even,
police.
they are offended.
Yeah.
But some of them decide to say, well, first, they may not understand the complexity of the courts. They may not afford the service of a lawyer. They don't know where even those courts are. So we have 6% of the public who do not have access to those courts that we are talking about. So when we talk about mediation, especially village mediation, if you go to a place like Malawi right now, where Lilongwe and Malawi and both parts of South Africa, they have come up with a system we know as village mediation. Disputes between the village level never find their way to court. People have been given some level of training, basic mediation training skills, the elders at the community level, they are solving disputes at that particular level. Not only that, you go to West Africa, they have come up with systems of resolving disputes before they get into the court system. So these are processes that has really grown in very many parts of the world, but it's growing very slowly in Kenya. Why? Before even we could urge mediation, because we started mediation and we want to support mediation, so many other things have come up. We have lost focus. And what I'm asking Kenyans to do is to come back. Let us promote mediation. Other parts of the world have gone very far.
It sounds a bit difficult in some cases, doesn't it,
Yes.
James? Because let's be honest,
Yes.
that sure, if you owe me money or we owe each other, it could even be 10 million.
Yes.
We owe money. There's a way we can sit down and have a conversation and say, yeah,
Exactly.
you can see I don't have.
Exactly.
Let me come up with you where I be paying you a little bit per month, even if it is bad. Even if I promised you I'll give you today. Today comes, I don't have, right? We can sit down and we can discuss that, isn't it?
Exactly.
Now, if we look at other cases where somebody has been raped,
Yes.
somebody close to you has been killed,
Yes.
isn't it a little bit more difficult for us to sit around a table and discuss, okay, let me think what you were thinking when you took the life of my beloved?
Exactly.
How?
That's why I'm telling you, even before you reach a point where you're making a decision that you need to mediate a case, there is a screening process. There are cases that cannot be mediated. That has to be very clear. And there are those cases that can be mediated. For example, let me just give you a very good example, probably, of a case you can just understand. There's a dispute between a husband and a wife on issues about custody of the children. The wife goes to court and gets an order of the court attaching the salary of the husband. And I know of a case similar like that, where somebody's salary was attached, which was 11,000. The guy was a guard. The court attached everything. Therefore, the all amount went to take care of the wife and the children. So the husband said, if I do not have money for transport, I can't pay my own rent. What am I doing in Nairobi? So the husband took his bag and resigned and went to the village. So now, here is the wife in Nairobi with the children.
There's
no
nothing
money
to attach.
Now, what did the court really do? Did it help in resolving the dispute? If this matter came to mediation, would have said this: you are earning 11,000. Why don't you take that 5,000 or 6,000 shillings out of the 11,000, give it to your wife? Let her take care of the child because he's holding your child, and the remaining 5,000 you can pay your small rent and get transport to go to fare to go to your place of work. Haven't we sustained that dispute? Than making a decision not knowing about the consequences. Now the wife had to follow the husband to the village.
But
they want to do the farming in the village.
I have a point that I need clarified here.
Yes. Yes.
Cases that you've given the example of family disputes, both parties are called.
Yes.
And the courts do interrogate
Yes.
the earnings of this person and what they do.
Exactly.
So, in a case where the court awards that entire amount, surely there's something wrong with that person who has issued that.
They didn't show up in court.
You see,
No. Even if you don't show up in court, matters that involve children, I want to assure you, it's not just the courts. You will find that the children's department gets involved. People come. A lot happens before that decision is made. It's not just people go to court and they sit there and the decision is made. Mediation is more sensitive And mediation allows both parties to talk to each other.
Yes, exactly.
The court doesn't. The court talks.
Yes.
And if you have somebody, and the individuals may talk to the court and explain.
Yes.
What I'm trying to say is that our courts may be busy and sometimes don't do what they should do. But before they issue a verdict, the truth is they do go into details. It's not as though it is rare that somebody would attach someone's entire salary.
Let me tell you, City, what you do not probably you may not know. In any disputes, usually there are 3 issues of concern to the parties. One, we have what we call substantive issues. These are the issues we write down and present before the court for determination. Then number 2, we have emotional issues. Emotional issues cannot be written down. They can only be expressed if the environment allows you to express those emotional issues. Then we have number 3, we have what we call pseudo-substantive issues. Pseudo-substantive issues are those issues that are emotional, but they are usually presented as being substantive. There are vehicles that carry those emotional issues. Now, the courts will only focus on substantive issues because these are the issues that have been presented before the court. The courts do not have the capacity of going into the emotional and pseudo-substantive issues because there is no training to that effect. And you'll find that 90% of the issues the cases that we have, contain 80%, the percentage of issues are, emotional issues are 80% in any case. So if we ignore the 80% and make a determination on the 20 or 15%, which are substantive, there is a lot that we have ignored. That's why, let me tell you of an example of a husband and wife who are fighting. And then you take the case before the chief. Now the chief will ask the husband, for example, the wife says, my husband doesn't eat my food. I just want you to listen to that one, City, very well. Because I want to tell you the difference between emotional and pseudo-substantive issues. The wife says, my husband doesn't eat my food. What the chief will do will ask the husband, why don't you eat your wife's food? Okay? And the chief will the husband will tell you, when I come in the evening, I pass through the bar, take a few bottles of beer, I eat my nyama choma, and I come home with my stomach full. And then I get home and somebody is trying to give me ugali and sukuma wiki. Where do I have to place it seriously? Should I really eat? Is it a must that I must eat? And then the chief will tell them, you see, you guys don't make noise. Fighting in the community, you disrupt the community. So stop this forthwith. Right? What has the chief done? Nothing. The chief has simply resolved substantive issues.
He actually hasn't resolved.
You see, therefore, once you can even tell the husband and wife to greet each other. And they go home and the fighting continues. What did the chief ignore? The chief ignored the emotional and the pseudo-substantive issues. That's very important to understand. So even the courts themselves do not have the capacity to delve into emotional and substantive issues, which are more important issues in the dispute. In mediation, we are trained to empathize. And when we empathize, we give somebody a license to tell us about their pain. There are issues that we hear that other forums cannot hear. And once those issues are resolved, you tend to get permanent solutions to disputes. I can tell you that. Let me give you an example, because I have examples I give you which bring points home very clearly.
Okay.
There's a person who sold his land without telling his wife. He sold all his land without telling his wife. And the person who bought the land went and processed title deeds. Those days you didn't require the spousal consent to do that. He went and processed title deeds. Unfortunately, this man who sold the land died. When he died, during the funeral, the new owner of the land came with the title deed and told the widow, I'm a gentleman. Please, after morning, just get out, get lost, get out of my land. The wife, the widow told this man, here we don't sell ancestral land. You made a mistake. So we are not moving. So the guy went to the chief and told the chief, I've been a gentleman, I've told these people to move and they can't move. The chief told him also, you would have asked. There are so many graves over there. Here people don't sell ancestral land. The guy went to court, presented the papers. He filed a suit to evict these people from the piece of land. He served these people with pieces of the summons to appear in court. The guy told the process server, not even the courts can evict us from this piece of land. So after that, this guy went to court, processed a decree, and in the decree was told that he would be accompanied with the OCBD of the area And he got some guys to go and evict the families. You know what the villagers did? When these people were coming, the villagers gathered together. They said there is no way this family will be evicted as we see. They were all armed with stones, sticks and arrows and rungus, and they were waiting for these guys. When the police officers saw that, they said, we can't shed blood for the property of one man. They told this guy to go back to court and tell the court these orders are incapable of execution. And these matters was never solved. Now, later on, I can tell you this guy had to come back after about 5 years. After I trained, there's a time I was training council of elders in mediation in different parts of the country. This guy came back to the chief and said, I hear you have trained mediators here. Is there any way I can be assisted? And this guy, they told him, now you can come. They asked him now. The elders, the chief told him, if you come before the elders, just tell the elders what help you want and maybe they may help you. The elders told him to come with the title deed and the court order. The first question they asked him, did that title deed help you? No. This 6 years down the line. Okay, do you want us to help you? Okay, tear it into pieces. The guy tore it into pieces. And he told me, did the court order help you? No. Tear it into pieces. If you want us to help you, he did that. And then they said, we want to pick 2 mediators who will accompany the family. Go and talk to the family. Whatever you agree, the elders will ratify it. So the mediators were appointed. They went and talked. The family agreed to give him a small piece of land, 50 by 100, towards the road. The guy said, at least this cleans my tears. And that's where he built his house. 2 years down the line, his son married from this family. Now that boundary had to move. Did the courts really help this guy? Did the law help them?
Yeah.
So that's why I'm telling you, if you want permanent solutions to disputes, we go either through community mediation or we go through commercial mediation, because mediation gives permanent solutions to disputes.
Okay.
It's important to understand that.
How do we get to you? Because that's where rubber meets the road. Because then again, we know I have a dispute, I go to the police, I go to the court, I go to the chiefs.
Yes.
But how do I get a professional mediator? Because then again, we are attached to the court annexed mediation.
Yes.
The likes of you, where do we get you?
We have the Institute of Chartered Mediators and Conciliators, which is a body that registers mediators. We have, if you need a mediator, we have Mediation Training Institute Mediation Center, where we have a panel of trained mediators who are bound by a very strong code of conduct. You can get mediators from there who are properly trained, qualified, and who have experience over many years. We have been training mediators for the last 24 years. Now, we have people, I tell you, who have experience, who mentor others. So here, I can promise you that you can get a mediator, not only who can do local disputes, but also who can do international disputes. And we are available. You can go to the ICMC website, the MTI websites, they are there, and you can get what we call a cooperative suit, where there is a list of mediators who are qualified and who are bound by a very strong code of conduct, who can handle your matters professionally. So they're available. We have that expertise in the country and all over the region. Yes.
Compare the cost of doing mediation towards the cost of a normal court case, for example. That this is not to brandish the courts, because the usefulness is it's clear where it lies.
Yes.
But then we also have the issues of how long it takes and how it can be wrapped up in judicial and processes for a very long time.
Yes.
So talk to us about the cost of going the mediation way as opposed to going the court way.
Mediation is not only cheap, it's very cost effective, because you can resolve a matter in a day. Yeah, and have it resolved in a day or in a week. In fact, the court annexed mediation, you have been given 2 months, but matters are resolved even faster than that. I have a case, for example, there's a time I used to train mediators at the Kenya School of Law. Even now I do train mediators. There's a young man, a young law advocate who had just been admitted to the bar, who went to his father's law firm in town and found a matter that had been in court for 17 years. He requested his dad, and this is a real life case, I'm telling you. He requested his dad and told his dad, I'm a trained mediator and the process works. Can you allow me to mediate this dispute? His father was a little bit skeptical. He said, mediation has been here even since the time of Jesus Christ. This is a complicated case. This matter cannot be solved. But his son insisted. And he told, please write to the other side and tell them I'm giving you them free service. Then the other side accepted, because they said, moreover, we have been in court for 17 years. We know mediation is a without prejudice process. If we don't agree, still we can come back to court. Whatever we discuss there cannot be used against the other in any subsequent legal process. So they agreed. The young man took them to Serena Hotel. Within 10 days, A matter that had been in court for 17 years was resolved within 10 days.
Wow.
In fact, as parties were getting out of Serena Hotel, they were shedding tears. Tears of joy that the matter had eventually been resolved, tears of bitterness, because this issue had really destroyed the relationship within the family. They had spent a fortune paying this in court. Now this matter was resolved in just 10 days. When this young man came to his father's law firm and told him, Dad, this matter has been resolved, his dad told him, you bastard. You mean you can solve this case in a week? Do you know that this is the case where we used to get money to pay our rent and pay your school fees? This is the kind of thing that we want to change in this country. People want to resolve their disputes faster. They want to resolve their dispute cheaply. And we don't want in the process of resolving disputes to destroy our relationships. That's why we are trying as much as possible to promote mediation, not only in the country, but in the continent. Because it works. Yes.
How critical is mediation aspect in terms of reducing case backlog in courts with regards as well to when you arrive at decisions and resolutions, is it filed in court? How is it enforced?
In fact, let me tell you that mediation has really assisted the court to reduce its backlog. Most of the cases these days are referred to mediation. They have a system in which they screen cases and refer them to mediation. The Chief Justice recently gave statistics on how much money has been brought back to the economy because of mediation. The settlement rates has been very high on mediation matters. Let me tell you the importance of mediation, even if the matter does not settle. When a matter is referred to mediation, people now at least get clear about what the issues are narrowed down, so that in case even if they don't agree, when these matters eventually come to court, they are resolved quickly. So mediation adds value, even if a matter is not solved. But it has done magic. In fact, the backlog of cases has been drastically reduced since mediation was introduced in 2015 through a pilot program. Right now, there's mediation in every court in the country. There are registries that manage mediation, and it has a serious impact right now.
Right.
Yeah.
How exactly do you enforce that decision that has been arrived at in mediation? Again, the legality will come in, because that understanding, is it binding, and how is it binding?
Good. The new regulations right now, that is legal notice number 145 of 2022, has given provisions of adoption of mediation agreement, be it even if it's a private mediation agreement. If people go outside their city and yourself resolve a dispute before a mediator and an agreement is signed, that agreement can be presented before the court. It can be adopted and be converted into a decree of the court. And that settles the matter. And the goodness about this decree of the court is that there is no appeal against a decree of the court that emanates from a mediation agreement, because they want to bring this litigation to an end through that system. Only that they have recently brought up provisions for setting aside decrees that come out of mediation on some specific grounds, some of them which are controversial. But any agreement made in a private mediation outside here can be brought before the court, and it can be adopted by the court and converted into a judgment of the court like any other judgment. Yes.
Very quickly, James, how does one become a mediator? We talk about how cases can be mediated, but there could be folks who, are sitting on a talent, can actually, because there are very many cases in court. There are also very many cases that require mediation. From your own admission, or is the pool already too full?
No. In fact, 2 weeks ago, I was in Brazil. And in Brazil, we have more than 300,000 mediators. And they are all PC. It depends on how we develop our mediation infrastructure in the country. Here right now, we have about 4,500 mediators. And only the court has observed 1,500, which means there are many others who are outside here. Still, we have a population of 60 million Kenyans. And there are so many cases that they find their way to court. Others are in police stations. Others are with the chiefs. In fact, what I would recommend, especially to the government, is to train chiefs and county commissioners and police officers, especially OC crime, those people who stay at the police station, they resolve disputes, to learn the skills of mediation. Some of the disputes that come to the chief, come to the police station, some of them need not find their way to court. If our police officers, if our chiefs were trained to be mediators, this is something that we can invest in, so that by the time the case comes to court, the issues are very clear. maybe mediation has failed. Maybe it doesn't qualify to be mediated because of the classification that I told you about. So we need to invest a lot in this country as far as mediation is concerned. Now, I need to tell you about the barriers that we have.
I mean, in a few seconds, because our time is coming
exactly.
through. Yeah.
There's general lack of knowledge about what mediation is. We have not really promoted mediation well in this country. In fact, 70% of the population doesn't know what mediation is. Number two, there is confusion of mediation with other alternative dispute resolution processes. We confuse them a lot. For example, you cannot talk about mediation and AJS in the same thing. You can't do both. Those are different because the mechanisms are different. And then there's resistance from some quarters about mediation, especially my colleagues, the lawyers. We need to work around that. So we need to have, first of all, a legislation. It's very important to work on a legislation to be able to cap the vices that they may emanate from this practice of mediation in this country. So we are working on a bill that will be presented before Parliament, and once this bill is up, it will contain most of the problems that we have right now and the issues to do with our practice. But mediation is here to stay. It's like River Nile. In fact, if you come on its way, it'll sweep you around the ground. So I'm encouraging all parties, all people in the country, the government and everybody else, please let us support mediation.
Indeed. James Magangere is the president of the Mediation Training Institute East Africa. Has been our guest this morning. Definitely eyes opened on some of these matters. Thank you so much for being here in the Situation Room this morning. Good morning. It's 8:01.